we're now going to move on to Jonathan Hang QC and to Daniel Clarke. They're busy practitioners acting on behalf of both claimants and defendants in chambers. They're both in the directories. Jonathan, clinical negligence and personal injury. Dan, very much known for his cross-border work, both personal injury and clinical negligence-wise. And it goes without saying that in addition to being fantastic practitioners, they're also wonderful colleagues. So I'm looking forward to hearing their update, legal update on Cauda Equina.
Elliot, thank you very much for that warm introduction. Good afternoon to everyone. I'm sorry we can't be with you in person, as people have mentioned already. As Elliot says, I'm doing this as a two-hander with Dan. Dan has the control of the slides, so I'm going to have to give him a prompt as we go along. And in fact, Dan, if you could move us on, please, to the first slide. Thank you. Thought I'd start with an overview. We're focusing, as you will have gathered from the schedule for this afternoon, on recent cases, liability cases involving Cauda Equina Syndrome, and dividing it up into two parts. I'm going to speak first on breach of duty aspects, focusing on delay in diagnosis and treatment, and picking up on a number of the issues that John Leach has already spoken about from the clinical aspect. And then Dan is going to speak on some cases, recent cases involving consent and causation. We will hopefully allow some time at the end for questions, which we'll be very happy to take. We'll put them in the chat box, and Elliot will then pitch them to us. So starting with my part of the talk, delay in diagnosis and treatment, I've focused on three recent cases. Two were first instance decisions: Shaw and Stead, claim against a GP, and then Jarman against Brighton Sussex University Hospitals NHS Trust, a claim against a hospital in relation to delay in diagnosis, or alleged delay in diagnosis of Cauda Equina Syndrome. And then thirdly, Hughes and West Hertfordshire Acute Hospitals NHS Trust and others, which is a decision, as you can see from the neutral citation, of the Court of Appeal. Certainly the Court of Appeal thought it was the first case involving Cauda Equina Syndrome and liability that had come before that court. Hughes was decided, in fact, a few weeks, the Court of Appeal's judgment came out a few weeks before the decision in Jarman, but it seems sensible to take the two first instance decisions in that order before turning to Hughes. But Dan, if we could have the next slide, please. Starting with Shaw and Stead, and the issue in this case was whether the GP was in breach of duty for failing to identify red flags for Cauda Equina Syndrome. Just looking at, to start off with the facts, the claimant was working as a teaching assistant, and on the Thursday she was kicked in the back by a pupil, and then she twisted her back as she stood up. And she went to see her GP the next day, complaining of bilateral leg pain, or pain radiating into her legs from her back. And the following day, the Saturday, she continued to suffer symptoms and spoke to the out-of-hours service, reporting, amongst other things, bilateral numbness and tingling in her legs, and was advised to attend the out-of-hours GP, which she did that afternoon. And he recorded a history of severe lower back pain radiating down the left leg, but, and this is the important point as it subsequently came to pass, no red flags. On examination, he noted that sensation was normal and diagnosed sciatica. But the claimant's condition deteriorated, and on the Monday she went back to see her regular GP. On examination, it was found that she had loss of power and sensation, and she was referred to the local A&E department, where an MRI scan was performed swiftly and showed a large central disc prolapse at L3, L4, confirming a diagnosis of Cauda Equina Syndrome, and she underwent emergency surgery that day, but sadly was left with significant disability. She brought a claim against the out-of-hours GP in relation to the consultation on the Saturday afternoon, essentially alleging that there had been a negligent failure to refer her to hospital on the basis at that time, on the basis that red flags were in fact present, and hence that it was mandatory to refer her immediately to hospital. And there was a preliminary issue trial before Mrs. Justice Yip just to decide the issue of breach of duty. Causation was rather complex and therefore was to be left over to another day. So Dan, if you have the next slide, thank you. Now, the first issue to look at in Shaw and Stead, although in fact it wasn't much of an issue because the GP experts were largely agreed about the standard of care expected of a GP in these circumstances. If the history and examination elicit red flags, then the GP must refer to hospital. Of course, a GP must take a history and conduct an adequate examination to determine whether there are any red flags. But, again, this is an important point, the GP experts were agreed that if red flags were in fact present, they would be elicited by a reasonably competent GP. So there was no avenue for the GP to argue, well, even with a competent examination, I wouldn't have picked up necessarily the red flags. The other point in relation to standard of care is that there was agreement, certainly in the circumstances of this case, between the experts that the red flags were any change in saddle sensation, any change in bladder or bowel function, severe or progressive loss of power in the lower limbs, and bilateral leg pain and or sensory disturbance. And so essentially what the judge had to decide was a factual issue as to whether or not the claimant, on the balance of probabilities, had red flags by the time of the consultation with the out-of-hours GP on the Saturday. And the judge decided that issue in the claimant's favour. And I think from a practice point of view, it's worth noting how the judge reached that conclusion. She was struck by two aspects of the claimant's evidence. The first was that the claimant described clearly a urinary accident which she had suffered on the Saturday morning on her way back to her bedroom from her bathroom. And then secondly, she described how when she left home on the Saturday afternoon to go to see the out-of-hours GP, she had had difficulty walking because her legs felt weak. As she described it in rather graphic terms, I felt like Bambi. The GP, who had no recollection of the consultation with the claimant, very fairly accepted that an immediate referral to hospital was required if there was any evidence of urinary incontinence or lower limb weakness. And I think it's a point both for claimant and defendant practitioners to bear in mind that those sorts of telling points in the evidence, assuming of course they're internally consistent and consistent with the other external evidence, really can make a difference, and they certainly did in this case to the outcome of the factual issue. So if we move on to Jarman and Brighton, and the issue in this case is whether the hospital it was in breach of duty for failing to arrange an MRI scan for suspected Cauda Equina Syndrome with sufficient urgency. You can see straight away this was a somewhat unusual case because the timescale was quite lengthy, and as well as breach of duty, you won't be surprised to hear that causation was also an issue, but I'm going to focus on the breach of duty aspects. The claimant in this case was a teacher who also suffered an accident at work on the 17th of February when she injured her back. And about 2 weeks later, having had ongoing symptoms during the intervening period, she attended A&E. She was seen by the orthopaedic team as well at the hospital, and the following day, after an MDT meeting, was referred for an MRI scan, which was performed on what was described as an urgent timescale, about 2 weeks later, as we can see, on the 18th of March. And that MRI scan showed what was described as a huge disc prolapse compressing the Cauda Equina. Cauda Equina Syndrome was diagnosed, and a few days later, 21st of March, she underwent surgery, but again, sadly was left with permanent neurological damage. The trial judge, Jason Coppell QC, sitting as a Deputy High Court judge, set out at the introduction to his judgment, paragraph 2, a helpful summary of the medical background of Cauda Equina Syndrome, and I set out there an extract from that paragraph, which I think chimes with what John was saying earlier. As the Court of Appeal has recently noted in Hughes, decided a few weeks before this case, once Cauda Equina Syndrome has been diagnosed, it's seen as an emergency because unless the pressure on the nerves is released quickly, they could be damaged permanently. Cauda Equina Syndrome may be suspected following consideration of a patient's symptoms, as subjectively reported, and following examination of any physical signs of Cauda Equina Syndrome, but a diagnosis of Cauda Equina Syndrome can only be confirmed by an MRI scan. So you've essentially got that two-stage process. First of all, is there sufficient in the clinical presentation to require imaging, further investigation by MRI imaging, and if there is, then of course, does that confirm the diagnosis? And if it does, there's then, of course, the need for emergency surgery. So moving on, the claim was brought against the hospital, as I've mentioned already, essentially saying there'd been a negligent delay in performing the scan. It should have been performed, the claimant said, within 3 days of being referred at the MDT meeting, so by the 7th of March. And if so, Cauda Equina Syndrome would have been diagnosed at that earlier stage and she would have undergone surgery shortly afterwards. Importantly, in the context of this case, the defendant disputed breach of duty, contending that the timing of the MRI scan was appropriate, and they relied on the fact that the claimant was not showing any signs of Cauda Equina Syndrome when she was seen by the orthopaedic team on the 3rd of March. Now, there are three main points that I think one can take from this judgment. The first is the question of, well, what's the standard of care for a hospital in these circumstances? And as a starting point, one might have thought that this was a relatively strong case from the claimant's point of view, because the orthopaedic experts called by both parties agreed that they would have arranged an emergency MRI scan by the 4th of March based on the claimant's presentation at A&E and in the orthopaedic department. But, of course, as we all know, that isn't the end of it, because applying the Bolam test, as the judge summarized it, paragraph 37 of his judgment, the question is whether in these circumstances there is nobody of reasonable opinion which would have supported arranging a scan for a patient in the apparent condition of the claimant on an urgent, i.e. about 2-week timescale, whilst giving the patient safety netting advice to return to hospital if there was any deterioration in her condition. And indeed, the defendant successfully defended the claim on the basis that the Bolam test was not met. And if we move on to the next slide, I've set out the key factors that swung it in the defendant's favour. And I think this is a point that picks up on something that John said in his talk, that the diagnosis of possible Cauda Equina Syndrome is a matter of clinical assessment based on the symptoms and signs, but of course, as we all know, there are a number of symptoms of the Cauda Equina that are also typical of other less serious back conditions, and there are resource constraints on scanning. Note the reference to resources. It's something that we will return to shortly in this case and in the Hughes case. And in this case, although in the words of the orthopaedic registrar who examined the claimant on the 3rd of March, she had several worrying symptoms, there were no clinical signs of Cauda Equina Syndrome on examination, and that wasn't disputed. The other point that the judge noted was that in this context, there weren't any published guidelines or literature or indeed decided cases to show that an MRI scan was required within the timescale of a few days that the claimant was contending for. And then the third point is in relation to expert evidence, because the judge was faced with orthopaedic experts who in some respects were very much at odds, and he looked to the well-known guidance back in 2014 in the CN North Cumbria University Hospital case of Mr. Justice Green, as he then was, who set out the various factors that courts should look to when assessing competing expert evidence, in particular the logic or reasonableness of the expert's opinion. And one point that the judge was particularly struck by in relation to the claimant's expert's evidence was the oddity, as the judge put it, of the claimant expert's opinion that if a scan was required, it was appropriate to wait for 48 to 72 hours before performing it. Going back to that introductory point, if you reach the threshold where you think a scan is required, then this should be treated as an emergency. As the judge put it, once Cauda Equina Syndrome is suspected, a scan should be performed as quickly as possible, in effect as an emergency, since Cauda Equina Syndrome can progress rapidly and irreversibly over a short period of time. And if you look at it in that context, the claimant's expert's opinion does seem rather odd. It's a sort of hybrid, and the judge certainly thought that that undermined the credibility of his opinion generally. So that's Jarman, and then moving on to Hughes, which, as I said earlier, is the Court of Appeal's decision in claims that were brought both against a GP and a hospital. So if we just start with the outline facts, the claimant, just after 6 o'clock in the morning, called the out-of-hours service and spoke to an out-of-hours GP, complaining of numbness in the saddle area. And indeed, the GP noted possible Cauda Equina Syndrome and advised the claimant to go to the A&E department at his local general hospital, District General Hospital, immediately. The claimant attended Watford District General Hospital about 2.5 hours later and was referred on to the orthopaedic team there, who suspected Cauda Equina Syndrome. It was not until about 12 o'clock that an MRI scan was requested, and then about another 90 minutes passed until the scan was carried out. And that was, in part at least, due to there being 2 other patients in the queue, as it were, waiting to be scanned. When the scan was performed, it revealed what was described as a massive L5-S1 disc herniation. The claimant was referred up to Queen's Square Hospital in London and underwent surgery at about 11 o'clock, starting 11 o'clock that same day, but again, sadly, was left with a permanent neurological deficit following surgery. The claim against the GP was put on the basis that there had been a negligent failure to refer directly to the orthopaedic team, rather than giving advice to go to A&E immediately. And the claim against the hospital was put on the basis of a negligent delay in investigating the Cauda Equina Syndrome, in particular in performing the MRI scan, saying that that would have led to surgery with appropriate management by about 3 o'clock in the afternoon. Now, both claims failed at trial, and the claimant appealed. If we could have the next slide, Dan, thank you. The Court of Appeal were careful to say that although this was the first case that they were aware of involving liability issues related to Cauda Equina Syndrome that had reached that court, really the case involved application of the established Bolam and Bolitho principles on breach of duty, at least. I think nonetheless it's helpful to see the application of those well-established principles in the context of a Cauda Equina Syndrome case. So if we take each of the claims in turn, the claim against the GP, the Court of Appeal really didn't have much time for the appeal on this point. Didn't have much time for the appeal on the other point either, but had looked at it in rather more detail. But essentially applying Bolam, the Court of Appeal said that the trial judge would have had to find that the only reasonable course was for the GP to contact the orthopaedic department directly. In other words, to short circuit the claimant having to go through A&E and in that way save some time. They said there really wasn't any evidence to support that finding. And they also noted, picking up on the resources point, that the out-of-hours service, they said, is a very busy service generally, and there's nothing to criticise in the conduct of this busy out-of-hours GP, who of course would have had to take time out from dealing with other calls if he was to make the referral directly to the orthopaedic department. So the dismissal of the claim against the GP was upheld on appeal. So far as the claim against the hospital is concerned, the Court of Appeal, again, upheld the trial judge's finding, or said the trial judge was entitled to find on the evidence that the period between the orthopaedic assessment and the MRI scan was not unreasonably long. A number of points that they referred to in that regard. Firstly, that the defendant's orthopaedic expert paid more reasonable attention to the workings of this type of hospital, including the resources, and they said there was no evidence that had been put forward that the prioritization of the MRI scan, with the other two patients going to be scanned before the claimant, was unreasonable. That was, in outline at least, the basis on which the claim against or dismissal of the claim against the hospital was upheld. But there are some broader points that I think are worth noting arising out of the judgment in Hughes. And if we could have the next slide, Dan, please. Firstly, in relation to the test for breach of duty. The Court of Appeal emphasised that when applying the Bolam and Bolitho test, what is reasonable depends on the context. And they said that the judge had applied the correct test in the particular context of the claim against the hospital. And what Lady Justice Elizabeth Lang said at paragraph 70 of the Court of Appeal's judgment, I think sums this up quite neatly. And it's helpful to have this in mind when looking at breach of duty in Cauda Equina Syndrome cases, and indeed in a wider clinical negligence context, saying the judge was right to use reasonableness as a touchstone while making it clear that what was reasonable depended on the context, and that part of the context was that on his case, the claimant was an emergency. The other part of the context is the relatively limited resources of a district general hospital in a busy public health service with many urgent cases competing for attention. And one can't help but note that both Hughes and Jarman were decided in late 2020. So right in the first wave of the pandemic, just over perhaps the crest of the wave, when one might think that issues of resources in the public health service were foremost, of course, in everybody's mind. But resources plainly is an issue, or potentially an issue in these cases, as the Court of Appeal emphasised there. And then the second point, if it needs emphasising, is simply that claimants, and indeed defendants, who bring appeals against findings of fact or findings of negligence face a high hurdle. And as Lady Justice Elizabeth Lang said at paragraph 64 in the judgment, the claimant therefore has significant obstacles to surmount in this case. It's not enough to persuade the court that a different view of the evidence was possible. The claimant has to persuade the court that the only possible view was that advocated by the claimant at first instance. And with that high test, and given the points that I've just outlined already, I think it was no great surprise that the claimant's appeal against both GP and hospital was unsuccessful. So thank you very much. As I said, very happy to take questions later on. I can see, looks like we've certainly got a few coming in, and over to Dan.
Thank you very much. Hello, everyone. So as Jonathan indicated, in my part of the this legal update of recent Cauda Equina cases, I'm going to be talking about two recently decided cases where consent and causation were the issues. And those cases are, as you can see, Pomfrey and Malik. Now, there's very much a common theme to these cases. In both of them, the claimants underwent surgery which was not negligently carried out, but where a rare or a small risk eventuated, leaving them both much worse off than if they'd not had the surgery at all. In fact, in both cases, pretty much catastrophically worse off. And in both cases, the claimants essentially took the point that but for the alleged negligence, they would have had the surgery at a different time, in other words, on a different date, and therefore they would have avoided the unfortunate outcome that they both suffered. So it's causation of a very particular kind, and both of the cases involve application of the House of Lords decision or at least consideration of it, in Chester and Afshar from 2004. Now, this is a really well-known case. I suspect very well known to a lot of you, so I'm not going to dwell on it, but I do think it'd be useful to have a quick recap of it, if anything, just to put these two cases into context. It will be remembered that in Chester and Afshar, Miss Chester suffered from low back pain, and her neurosurgeon, Mr. Afshar, advised her to undergo an elective lumbar surgical procedure, specifically a microdiscectomy on three levels. And that he advised her that on the Friday, as you probably know, and she had the surgery on the Monday, in other words, 3 days later. And there was no negligence in the way that it was carried out. However, the procedure entailed a 1 to 2% chance of serious neurological damage arising from the operation. And unfortunately for Miss Chester, this risk eventuated, specifically a Cauda Equina contusion, leading to motor and sensory impairment on her left side below L2. Now, the critical thing was that Miss Chester was not informed of this pre-operatively, and that, at least that was the finding, unappealed, and that was negligent of Mr. Afshar not to inform her of that. And the evidence was that if she had been warned of it, she would not have agreed to undergo the operation on that day. In other words, on that Monday, she would have taken further advice, but it was undetermined whether or when she would have undergone the surgery subsequently. But what was also found and not appealed was that the surgery, whenever carried out or by whomever, would have carried the same 1 to 2% risk of this unfortunate outcome occurring. So the critical issue in Chester and Afshar was whether this breach of duty caused Miss Chester loss. And famously, the House of Lords was split 3-2. The minority said no. Essentially said, well, with the breach, her risks of suffering this outcome was 1 to 2%. Without the breach, her risk of suffering this outcome was 1 to 2%. It was the same risk either way. Therefore, the breach hadn't increased her exposure to the risk, and she hadn't established that she would never have had the operation. So that also, the injury was as likely to occur whenever the surgery was performed and whoever performed it. So no loss, essentially, and not caused any loss. The majority said yes, the breach had caused loss. And there were essentially two different bases for this. And the first, which probably gets more, it's fair to say, more emphasis in the House of Lords judgment, perhaps the more controversial basis, I refer to it as the policy basis. And this was essentially a finding by the majority that this particular, advising about this particular risk fell within the scope of the doctor's duty to advise the patient of disadvantages or dangers of the treatment proposed, because it was specifically within the scope of Mr. Afshar's duty to warn. Then justice required a narrow modification of the traditional causation principles in this particular case. That was the sort of policy basis. The second basis, which also appears in the judgments, it probably doesn't get the emphasis, is a sort of but-for argument. And essentially, this argument, reasoning, this argument runs as follows. If she'd agreed to the surgery at a subsequent date, she would again have faced a 1 to 2% risk of this outcome occurring. And because that's such a low risk, then it's unlikely that it would have eventuated. So to use a sort of crude analogy, if one imagines that there was a dice with 100 sides, and that it has to land on 1 or 2 for the risk to eventuate. In the surgery, which she did have, the dice was rolled and landed on 1 or 2. But if she'd had the surgery at a subsequent date, the dice was rolled afresh. It's most unlikely it would have landed on 1 or 2 again. That is quite a crude way of putting it, but that is essentially the nub of it. Chester and Afshar has obviously been much debated ever since. The correctness of the reasoning on both bases, how far does the policy limb go in particular. It's certainly been restricted or confined by subsequent calls for appeal decisions to clinical negligence cases, and even in that context described as exceptional. So it's not something that's spread widely across tort or even across clinical negligence generally, but it's still there, and it does continue to be relied upon in clinical negligence cases, and particularly in Cauda Equina claims, which then brings me to the High Court decision in Pomfrey, where it did pop up. So in Pomfrey, the facts were these. The claimant, Mr. Pomfrey, had constitutional degenerative disorder of the spine. And this culminated, or eventually he was operated on the 24th of January 2012. And this operation, as I hinted at earlier, wasn't in any way carried out negligently. Unfortunately, however, during the course of the operation, he sustained a dural tear, and this was extremely serious. He had, I think, no fewer than 5 revision surgeries to correct it. There was a leak of CSF. He suffered infection and the pain condition erythroiditis, and he was left with pain, double incontinence, and mobility issues. So it was catastrophic for him. Now, his case, there were 2 essential parts to his case. The first point he took was essentially that he had compression of Cauda Equina nerve roots for about 9 months or so before the operation in January 2012, and been displaying symptoms of those. And the defendant trust should have referred him and operated on him sooner. In other words, had they operated on him sooner, he would have had a better outcome. The second part of his claim was to say that had the surgery, which he did have on the 24th of January, been performed on any other day, he would have avoided what happened on the 24th of January 2012. In other words, this unlikely or rare outcome, the dural tear. So in other words, squarely raising the Chester and Ashar argument. The trust case was that he did not have compression of Cauda Equina nerve roots before the operation. The symptoms that he displayed in those 9 months were due to spinal claudication arising from spinal stenosis. So there wasn't any breach. In other words, there wasn't any delay in treating him or carrying out the operation. He was treated appropriately for the symptoms he had. And the CES he had subsequently was caused by the dural tear in the operation itself. That was the trust case. So what did the High Court find? Well, on the first part, that the preoperative scans didn't demonstrate compression of the nerves, that the claimant hadn't been suffering from saddle anaesthesia preoperatively either. Those were the 2 really critical factual findings, in particular the finding about saddle anaesthesia. The claimant had given evidence that he'd reported to multiple clinicians that he had the sensation of sitting on a milking stool, so he put it. But the judge found that he was entirely unreliable as regards that recollection, which I think it's fair to say didn't appear in the notes. So given those 2 factual findings, it was found that there'd been no negligent delay, apart from in one respect, which I'll come to in a moment. But generally, there'd been no negligent delay in the carrying out of the operation. And further, the ongoing symptoms that he was suffering from were attributable to the dural tear sustained in the operation itself and not pre-existing CES. On the second strand, which is the bit that sort of, I suppose, interests us more because it's concerned with the Chester and Ashar point. On the second strand, the claimant's case was that he should have been operated on 10 days sooner. And this aspect, the judge did uphold. There had been a 10-day delay. He ought to have been operated on by the 14th of January, rather than the 24th, which is when he was operated on. And the claimant's case was that, well, had that happened, I would have been facing again a 5 to 10% chance of a dural tear, and that's an unlikely chance. In other words, you roll the dice again, and it's only a 5 to 10% chance it's going to land on a number that affects me. And the hypothetical surgery wouldn't have been identical to the surgery that was carried out because it cannot be, by definition. Essentially, was the way it was argued. In other words, essentially an application of the but-for case in Chester. Well, the court said no to that. And the way it was dealt with is interesting. Essentially, the court took a very close look at the mechanics of the operation and exactly how the dural tear had occurred, and essentially came to the view that whenever the operation been carried out, although it was found it was very likely to be carried out by the same surgeon, probably about 10 days earlier, but it was most likely that it would have been carried out in the same way and the same problem would have occurred. In other words, to quote the passage I've put there, same surgeon, physiology, same difficulty with depth technique and use of punch in same spot. And the court really reached that conclusion following quite a close analysis of the precise mechanics of what had happened during the course of the surgery. And there wasn't any reason, as far as the court could see, why what had gone wrong, which was the raising of the punch during the course of the surgery, why that wouldn't have happened the same way had the operation happened on another day. And that's interesting because instead of looking at the risk that eventuated purely in percentage terms and saying on a general basis how likely is this to have happened, there's a much sort of closer and more sort of immediate analysis of exactly how it happened. Was that particular thing likely to have happened again? So it failed on that ground. And on the policy argument, and the court held that Chester was distinguishable. In Chester, the injury was within the scope of the duty to warn. But here, the scope of the duty, it wasn't a duty to warn case. The scope of the duty was to avoid unreasonable delay, and that didn't extend to avoiding a risk inherent in the surgery itself. So on that basis, Chester didn't apply either. So that's Pomfrey. Malik, second case, raised a similar issue. In this case, the claimant attended A&E in 2014 with pain and weakness in his legs. He had an emergency operation, which was a decompression at 2 levels, at T10, 11 and at L3, 4. And then he had a slow and incomplete recovery from that. He then had a second operation in August 2015, again at 2 levels, a revision of the thoracic decompression, the exiting nerve root on the left-hand side at TN, 11, and a lumbar decompression. And again, there was no allegation even that the surgery was negligent in itself, but Mr. Malik was rendered significantly worse off and in incomplete paraparesis and confined to a wheelchair as a result of the operation essentially going wrong and sustaining neurological damage during the course of the operation. Now, there wasn't, I don't think, a sort of clear finding about what the risk was of that happening during the course of the operation, but it was the evidence of the treating clinician that this was a less than a 1% risk. And the claimant's case was essentially that he hadn't been consented properly for the second surgery, hadn't been given any indication of any potential adverse outcome. And secondly, he ought to have been offered an alternative, particularly or specifically the alternative of pain-killing injection. And he also alleged that had the surgery happened on a different day or a different time, then it's unlikely that this 1% risk would have come to pass on that other occasion. In other words, raising the Chester and Ashar argument. Claim did not succeed. The court found that the consent had been properly obtained. He was warned of risks. There were criticisms of the evidence and recollection on both and the record keeping and on both sides, but ultimately the court found that the claimant's evidence about this aspect was unreliable. Further, the court found that Mr. Malik did complain to the treating clinician of terrible intercostal pain, and it was this shortly before the operation in August 2015 that justified the diagnosis of compression of left-sided T10 nerve root and the recommendation for the procedure that he underwent in August 2015. And the court went on to say it wasn't negligent not to offer the alternative of injections in this case. There was a long waiting list for those, and they would only have provided short-term relief anyway. So essentially, the court found that alternative that the claimant had said that he ought to have been offered was unrealistic, and there's no breach in not offering it. On the causation point, specifically on the Chester point, that failed on the fact the court did go on to consider this, even though I think strictly probably didn't need to, given its other findings. But what was said was that given all the information and options, Mr. Malik would still have gone ahead with the operation on the same date in August 2015. He wouldn't have sought another opinion or delayed making his decision. And on those facts, you can see that there's absolutely no room for Chester analysis at all. So it simply fails on the facts. Although the arguments derived from Chester and Asher failed in both of these cases, still very much alive in Cauda Equina cases and in other clinical negligence cases as well, and it is likely to keep occurring. And it also seems likely to me, anyway, that it's going to receive consideration from the Supreme Court at some point. In Juice, Lord Justice Leggett commented, having gone through the House of Lords decision in Chester quite a lot of detail and criticised it pretty firmly. These are all matters which may be thought right for further consideration by the Supreme Court when the opportunity arises. And it does seem that the opportunity probably will arise. It may not necessarily be in a Cauda Equina case, but it does seem likely it will arise at some point. That brings an end to my talk. I hope I've not overrun too much.
You haven't at all, Dan. That's fantastic. Thank you both to Dan and to Jonathan. That was a very illuminating discussion, and it's quite a reminder, isn't it, of how often these cases are fought, even though they're comparatively rare. So that was really helpful. And I see amongst the chat just the one question which has been put, and I think probably one for you, Jonathan, which may be a tricky one to answer unless it's been mentioned in the judgment. But the question was, I think, in relation to the Shaw and Stead case at the beginning. Do we know why the first general practitioner was not sued given bilateral leg pain on the Friday?
Yeah, well, I spotted the question. This is one of the joys of doing it this way, and I've had to delve back into the judgment in Shaw and Stead. Perhaps not surprisingly, it's not spelt out, but I did note that the GP who saw the claimant on the Friday recorded bowel bladder movement today, suggesting that there was no bowel or bladder dysfunction at that point. And I wonder, and I can't say more than that, whether, given the evidence that they had about what happened on the Saturday, those two events that I pointed out, the claimant's advisors took the view that they were going to be stronger against the out-of-hours GP on the Saturday, and that from a causation point of view, 24 hours or so might well not have made much, if any, difference. And so if they were stronger on breach of duty against the out-of-hours GP on the Saturday, that's why they aimed their fire at him. So I don't know for sure, but I suspect that's what it was. But well picked up. Certainly a potential claim against, it would seem, against the GP for the Friday consultation as well.
And the tactic which seems to have worked anyway for them. No, thank you both very much indeed, and see you at 10 past.